Well, people deserve to get paid for the work they do, no matter what kind of work it is. And in the adult entertainment industry, clubs take advantage of the vulnerable workers simply because they can. Most of the women who dance in these clubs are low-income women, oftentimes single mothers, who don't feel like they have the power to come forward, and that's exactly why these clubs take advantage of them. So what Fantasy Gentlemen's Club was doing was designating its employees, the dancers, as independent contractors in order to avoid paying them for their work. But it was worse than that. They would actually charge them to be allowed to work and then use the dancers' own tips to pay the other employees. And so by the end of the night, it might come out okay, but they might come out actually owing money to the club, having spent their own tips paying the DJs and the bouncers. It's really outrageous. In this case, the club's treatment of these dancers was so profoundly unfair that we actually sought a plaintiff's summary judgment. And that's incredibly rare, but the treatment here was so profoundly illegal that in fact we were able to do that. Unfortunately for us, Mr. Eardley, Fantasy Gentlemen's Club, and their lawyers went through all kinds of shenanigans to stay out of court and to try to avoid accountability, including filing for bankruptcy. And as we all know, that just stays the entire case. And so we were forced to bring in a bankruptcy attorney.
It was a Chapter 13 filing for Mr. Eardley personally, and then a Chapter 11 filing for the Fantasy Gentlemen's Club. There was an effort to portray it as being not financially successful, cash poor, and essentially worthless, when in fact it was a cash machine at the time. The nightclub, as you would guess, has a safe, and under oath Mr. Eardley was asked how much money is in the safe on the petition date, and he couldn't even venture a guess from $1 to $300,000. It was just an unknown amount in a safe. He had the usual collection of toys you might expect for someone who owns a nightclub of that nature, including a speedboat valued at approximately $75,000 to $100,000. Those kinds of things don't fly in bankruptcy court, and they didn't fly in this case either.
Eventually, against all odds, we were able to achieve an outstanding result in this case. And that was a judicial finding that the way that this club was operating was in fact illegal, because they are in fact working as employees and they deserve to be paid for the work they're doing. Because this case was filed in the United States District Court, it's a federal ruling. It impacts not just the entire state, but really serves as legal precedent that impacts clubs like this throughout the entire country. There is no worker that deserves to be oppressed in the way that these dancers were oppressed. And one club at a time, we're going to fix that. We were watching as Kevin Eardley was bit by bit disgorging all of his assets. And so the worst one was when he actually transferred the property of the club, the only really huge asset he had, into his mom's name. So we were trying to figure out how can we make sure that at the end of the day these women really are paid for the work that they did and actually get the settlement that we negotiated. What we did was arrange for not only Mr. Eardley to sign over a deed of trust for the club, but his mom. And so that meant at the end of the day, if Mr. Eardley didn't pay these dancers, they would own the club and we would own part of the club. Not that any of us really wanted that club, but it seems only fair, don't you think? By focusing on these cases, the CTLA gives a voice to the voiceless and really gives an opportunity to try to change behavior. And so thank you, CTLA, for really focusing on these cases, representing people who really need to be heard.